In my judgment, the proper approach to determining the sentence here is to look at the various offences individually and determine the appropriate sentence for each. Then I'll make the appropriate upward adjustment to the sentence for murder, first for the aggravating features of that offence, and second to reflect the other offending. Then I will make the appropriate reduction for mitigation and considerations of totality. Since I am not satisfied that this murder itself was one of particularly high seriousness, the appropriate starting point is 15 years. However, I increase that to reflect the vulnerability of your victim because of both his age and his previous injuries, the fact that this was a gross abuse of trust by you as his mother, and the fact that it was committed in the presence of another child, your younger son. That would lead me to increase the sentence for the murder alone from 15 to 22 years. I increase it further to reflect the other offending. In determining what further increase is appropriate, I've had regard to the Sentencing Council guidelines for child cruelty and to the appropriate sentences if the other offences had each stood alone. In my view, had it stood alone, count 3, the scalding incident, would have been regarded as a category B1 case, the use of scalding water amounting to the use of a weapon, and the dreadful burns amounting to serious physical harm. In my view, if that had stood alone, it would warrant a sentence of 6 years custody. Count 5, the failure to seek treatment for the burns, would inevitably have been treated as an aggravating feature of count 3. It constituted serious and prolonged neglect and would have justified an increase of 2 years. Count 4, the beatings, if viewed alone, would fall into category B2, high culpability, medium harm, and attract a sentence of 3 years. Count 6, the abandonment, would fall into category B3, medium culpability, low level of harm suffered, and that would on its own attract a sentence of 1 year. I note in passing that the top of the appropriate bracket for a single offence of child cruelty, falling within category A1, is 12 years. If the child cruelty offences in your case were viewed as a whole, they would certainly attract a sentence of that order, if not more. In deciding by how much I should increase the sentence for murder to reflect the other offending, I bear in mind that had these sentences stood apart from the murder, you would have been eligible for parole in respect of them at the halfway point. In my judgment, the appropriate increase to reflect the other offending is 6 years, taking the total to 28 years. I must then make allowance for your mitigation and for totality. The mitigation available to you is that you intended really serious harm to Dwelaniyah, but not his death, and that you had no previous convictions before these incidents. I then stand back and consider what sentence is just and proportionate as a whole, reflecting all your offending behaviour, the overall harm, your overall culpability, and all the aggravating and mitigating factors relating both to you personally and to the offences. On that basis, I deduct a total of 3 years to reflect the 2 mitigating factors to which I have referred and totality. Miss Robinson, stand up. For the offence of murder, you will go to prison for life. The minimum term you will serve before you become eligible to apply for parole will be 25 years. You can go down.